Good evening, everybody. I'm Eric Feil of Richner Communications, and I am so excited to welcome you all here tonight for our webinar, Inside LI webinar produced by Richner Live. This is Living 50 Plus, Health, Wealth, and Self. This is presented by AARP Long Island. It's the second in a three-part series. The first one was all about, of course, the health. We talked about eating healthfully, getting a great diet. Now tonight is all about wealth. And it's not just dollars and cents, but a wealth of information that is coming your way. Now, the key, of course, to getting information is to know where to look for it, right? Well, the 500 plus of you who signed up and are here with us live tonight, you need look no further than right at your screen, because we have two incredibly knowledgeable, experienced local attorneys who know about all of the subjects, whether it is estate planning, Medicaid, Medicare, wills, trusts. We're going to hear all about it. It is my great pleasure to welcome here this evening Ron Fatula and Constantina Papageorgiou. And now to kick things off and to start us down this road to 10 steps to a better retirement, the first step, I always say, starts with our friend Bernard Macias. He is excuse me, the Associate State Director, Long Island, AARP, New York. Bernard, welcome.
Well, thank you, Eric. I like how you cleared your throat to introduce me. How wonderful. All right. Well, greetings, everyone. On behalf of AARP New York, I want to welcome you to tonight's Wealth webinar from our series titled Living 50 Plus, Health, Wealth, and Self. This is part of our three-part webinar series. And I am the Associate State Director for Community Outreach and Engagement for AARP right here on Long Island. I serve close to 500,000 members across Nassau and Suffolk counties. AARP nationally, we're 38 million members strong nationwide, but 2.5 million of those members live right here in New York State alone. And so out of those 2.5, 500,000 of those members are right here on Long Island. So a little bit more about AARP. We're the nation's largest nonprofit, nonpartisan organization dedicated to empowering Americans 50 and older. I want to just remind our audience today, we start at 50, and it's all about how we want our members to choose how they live as they age. AARP works to strengthen our communities and advocate for what matters most to our members, but especially to their families, with a special focus on health security, financial stability, and personal fulfillment. So if you remember anything about AARP, remember that we're all about health, wealth, and self, which is why AARP Long Island teamed up with Herald Inside LI to proudly present this three-part webinar series. So like Eric mentioned, last month was all about health. We had a wonderful program for all of you, a 101 on eating well and talking about fruits and vegetables. And plus we had a live cooking segment that people really enjoyed. Tonight, our focus is on wealth, where our panelists are going to be sharing a lot of important information and tips and have an open dialogue with all of you on how to better prepare for retirement, a really important topic. And next month, it's all about self. We're going to have a special personal fulfillment presentation on how to best declutter your space and while you declutter your mind at the same time. So consider it a time for cleansing and for your home, for your personal life. And we're going to be talking to experts next month on that. So as you can see, these webinars will cover different, range of topics. And again, I want to thank you for joining tonight's webinar. At AARP, we're focusing on supporting the communities throughout the state with opportunities to connect without leaving your home. We're offering many ways to keep you and your families engaged and informed online. And in fact, right now we're doing a campaign where we call it like, did you know that the younger you are, the more you need AARP? So please connect with us at AARP Long Island. And you can visit us at our website, aarp.org/near-you, to learn more about other events, webinars, at-home activities, classes, volunteer opportunities. We have a lot of different opportunities available to you to volunteer virtually with us. And you can also find us on Facebook at facebook.com/AARP Long Island. So Eric, right back to you and this wonderful program we have tonight.
Well, thank you so much, Bernard. You raised such an interesting point there when you mentioned that AARP, and this is 50 plus, but the younger you are, the more you need it. And that really goes to the point of what we're going to hear a lot about here tonight. It's starting and planning and learning as early as you can. This is not just for people who are getting into retirement, but thinking decades before. And it can be for yourself, for a family member, for a loved one, whether it is financial concerns, health concerns. The earlier you can start planning and the earlier you can start gaining that knowledge, the better. So with that, I think let's dive right in. The whole idea of lifetime planning. And Constantina, would you like to kick things off on that topic?
I would. Thank you. Thank you so much to both of you, Eric, Bernard. Thank you to the Herald and to AARP for having us here today. This is really such an important topic. And going to your point, I always say you need an estate plan the minute you turn 18 years old. A lot of our clients who come to us and say they need to do their own wills, we get into discussions about their kids, about, where their kids are, what they're doing. A lot of them are in college. You try to get any information from a college about your 18 or 19 or 20-year-old, you're not getting anything without appropriate documents, without a healthcare proxy for medical information or a power of attorney for financial. So it is very important to start this type of planning young. 18, I think, is the perfect age for this to start. And once you start there, you just build on it. So yes, I would like to kick off with just the basics of estate planning. Lifetime planning is what I call it. There are 4 basic documents that I always recommend my clients do not leave me without. I'm going to cover the first 3, and then I'll pass the torch on to Ron to keep going with it. Lifetime planning is a huge part of estate planning that a lot of people seem to neglect. They seem to think, well, I did a will, I don't need anything else, but that's not sufficient. A will really only covers you after your life, when you've passed away. And for me, I'm an elder law attorney, trust estates and elder law. And so I tend to help families and help individuals during times of need, when they're not capable of handling their own finances or making their own medical decisions. And that's really the hardest part of somebody's life, is the point where they may have, concerns or issues and things that they can't do on their own. So it is very, very important to make sure that these documents are in place. And I'm gonna cover the first 3. The most important to me is called a power of attorney. Power of attorney is the document that allows you to nominate someone to stand in your shoes, to help you with financial decisions, to deal with your insurance, to deal with your banking, your real property, collecting rents from your tenants if you have them, dealing with your business. And this document is just a very important document, because without it, you end up going down a road where it becomes very difficult to navigate. You involve the courts. You involve getting a guardianship over the individual who may not be capable any longer to make those financial decisions. And so having an appropriate power of attorney in place is key. And I say appropriate because it's very easy to print a document off a website, right? To just Google power of attorney, print it, sign it, and be done with it. But those are typically not sufficient. They don't have the powers that I would need as the elder law attorney, or as the attorney who's trying to do special types of planning for somebody who may be at the end of their life, or approaching an illness, or already suffering from some sort of illness, to get the appropriate assistance that they need. So it is very, very important that a power of attorney be drawn up that will meet the needs of the individual who is signing it. It also is very important for you to nominate somebody on the power of attorney that you absolutely trust. That document is a very powerful document. It will allow somebody access, unfettered access, really, to your finances, to your personal items, and it will ensure that that person can do everything that you want them to do for you. So it is very important that you trust the individuals that you nominate on it. The second document is called a healthcare proxy. The healthcare proxy is where you nominate somebody to make your medical decisions in the event that you could not make them yourself. And it's very important to have a healthcare proxy in place to ensure that the appropriate individual, the right person who is advocating for you, is making the decisions that you would have made had you been capable of making them yourself. The third document is called a living will. A living will states what your end of life decisions are. It kind of gives your healthcare proxy some guidance and advises them, look, if I'm at the end of my life, if I'm in a position where there's no reasonable expectation that you would recover, that I would recover, don't give me treatment that just prolongs the dying process, whether it be artificial means of hydration and nutrition, whether it be PEG tubes and ventilators, or even, toward the end, CPR or other types of treatment that would keep you here. It's pointed toward the end of life, right? And so it's important to have that in writing, because I feel like there's just so much that can be misconceived, or just families may be at odds at that point, right? There may be a scenario where a parent is not doing well and a child says, well, mom told me this. And then another child that says, well, no, mom told me something totally different, right? So having that document in place ensures that mom's wishes are actually going to be followed because they're in writing. And that's really the overall theme to most of what we're going to be talking about. Having a plan in place, ensuring that the right people are nominated by you in these documents that are absolutely necessary to have, to make sure that if there came a time when you are not capable of making these decisions, that the people that you want to make them are making them for you. And so it's very important to have these three. Without these documents, what ends up happening is that you may reach a point where you're no longer capable of making decisions. Let's say somebody who's had dementia for several years, who reaches the point where they can't make financial or medical decisions. At that point, they can no longer be able to execute the power of attorney, because to execute a power of attorney, you have to have your utmost capacity. You have to understand what you're doing. You have to understand your assets. You need to be able to make these decisions. And if you don't have a power of attorney by that point, your family or your loved ones may be stuck in the only option that they have available, which is going to court to seek a legal guardianship. And I could talk badly about guardianships all day. I'm in guardianship court once a week. I am a guardian for several people who didn't have these documents in place. If the court calls me and says, Constantina, we need your help with another situation that is typically very messy, which is why the court appoints an independent attorney to do it. So it's very important that these documents be put into place to avoid that kind of scenario. It's a very costly option, and it takes a lot of time and a lot of patience dealing with the courts. So get your documents in place, start with your advanced directives for your lifetime planning. And now I'm going to pass on to Ron so he can talk to you about the next step.
Thank you so much, Constantina. That was terrific. I do have a bunch of slides that I'm going to show on the screen in just a moment. However, actually, let me just get that on. I do want to thank Bernard. Thank you, Eric. Thank you to the Herald and for putting this all together. I think this is so important. The fact that over 500 people signed up for this just shows us how thirsty the public is for this kind of knowledge. And I think it's just so important. So thank you guys so much. And Constantina, that was terrific. There's one point that you kept hammering in, and I'm just going to add a little bang to that hammer as well. You want to go out there and you want to plan. It's never too early to plan. If you're 18 years old, like Constantina said, you go to college. Well, the parents want to know what's happening with their child and probably make healthcare decisions. So you want to do the documents that Constantina was talking about. I now am going to be talking about wills and trusts. And then it'll go back to Constantina, who'll talk about succession planning. So let me share my slides. Here we go. And I actually have lots of slides. And I typically do have all of these slides so that individuals can get the slides afterwards and review many of the things that I'm talking about. So just know that it's here. Don't focus on reading all of this. But number one, before we get into wills and trusts, you gotta get your team together. It's the attorney, the estate planning attorney, elder law attorney, such as myself, such as Constantina, so important. And we interplay with the financial advisor, and we interplay with the CPA. And if there's a care need, there might be a geriatric care manager. And we as the attorneys will interplay with everyone. And it's absolutely crucial that for example, that the financial advisor knows how to manage and distribute the assets from the trust that I'm going to be talking about. Because one little blip going the wrong way, and this happens once or twice a month, there's an issue with a client. I always tell the client, don't do any distributions on a trust unless you speak to us. But if there's an advisor that doesn't understand, it could absolutely ruin the plan. So let me start off with the last will and testament. I assume that most of you know that a will is a document that sets forth where your assets go when you pass away. The individual that creates that document is called the testator. The individual named in the will that manages the assets will get letters testamentary so that they can operate and eventually pay debts and distribute the balance to the beneficiaries set forth in the will. Many times individuals ask, well, can the executor be a spouse? Can an executor be a beneficiary? And the answer is, of course, yes, you can. Just like Constantina mentioned with the power of attorney. Power of attorney and a will is not a DIY document, a do-it-yourself document. Clients get trapped into thinking they could just do it. And with the power, there are so many extra powers that we need. With the last will and testament, simply put, even if you could download the right type of will, there's a presumption that when the attorney drafts that will, that it's a valid will. And that goes so far when we have to probate that will later on. So what about wills versus trusts? What is probate? Well, a will gets probated. Many people come and say, well, I want a will so I could avoid probate. It's not exactly how it works. When you have assets that go through the will, then the will be probated. It's a living trust that avoids probate for the assets held by that trust. Why a trust? Well, the trust is not a public document. It's private. It expedites the distribution of assets. Things happen much quicker. And a living trust also helps to avoid a will contest. So what is a trust? A trust is an agreement. There's a trust agreement that we would draft that creates an entity. And this entity called a trust holds assets, will hold your assets. And those assets will be managed and distributed in the way that we prescribe in that trust. There are revocable trusts, the irrevocable trusts, but when we want to protect assets, let's say for Medicaid or for estate planning or for estate taxes, assets have to be transferred over into that trust agreement. And a living trust is fine. It could last an individual's lifetime It could last even beyond an individual's lifetime pursuant to the terms of the trust. But look at the last bullet point. When could you terminate the trust? When the trust says that it terminates. Or if it's a revocable trust, when you revoke it, or upon the contingencies set forth in the trust. You might say, well, I'm going to have this living trust upon my death, it terminates, and that's fine. Now, the parties to a trust are the grantor or settlor or creator. That's likely you, the creator of the trust. The trustee is the individual that manages the assets of that trust. Could be you, could be someone else, could be a child, could be children. And then we have beneficiary or beneficiaries. Who's going to get? Well, you could be the, for example, income beneficiary, where you get income during your lifetime while you're protecting assets for Medicaid. And then upon your death, your children could be the remainder beneficiaries. I'm simplifying things. Again, a trust is not a do-it-yourself document. It has to be done exactly right. And there are living trusts for so many different reasons. But for our Medicaid trusts, because I'm going to be talking about that in the next section, there are so many benefits to that living trust, where you can get assets out of your name for Medicaid, but retain all of the tax benefits that you would have if you actually held the asset in your own name. So I'm going to get into that in just a moment. But if we're doing a Medicaid trust, that trust must be irrevocable. It's better if you are not the trustee. You could say you want the income for the rest of your life, and principal will go to your beneficiaries. But the advisors that are managing those assets, that financial advisor, has to be very careful on how he manages and distributes those assets, how he or she does that, because that could mean protecting your assets or not protecting your assets. So when we do this, we need to educate the financial advisor or use someone that also knows exactly what they're doing. So the advantages of the Medicaid Asset Protection Trust is, for example, you could preserve your home, you could live there, the assets out for Medicaid purposes. Currently, there's no waiting period at all if you need Medicaid home care. There would be a wait for Medicaid nursing home care. So you want to get this done as soon as possible, just as Constantina said. You could still keep all of your real estate tax exemptions. You could even keep the $250,000, and husband and wife would have $500,000 exemption from capital gains taxes, just as if the home were in your name. But you're getting protection for Medicaid. You could transfer your brokerage accounts into this trust, still receive the income, but protect the assets for Medicaid. Why Medicaid? Because you want to figure out a way to pay for long-term care, get income, and protect your assets. This slide goes over the benefits of a living trust as opposed to an outright transfer. And with the living trust, upon death, let's say you have your home in the trust and you paid $50,000 for it, but now it's worth $1 million. Your basis for capital gains taxes will be stepped up to the full market value at the time of death. There'll be no capital gains for your children or whoever the beneficiaries are. You do get that $250,000 or $500,000 capital gains tax exclusion if the home is sold while held by the trust. You don't have to wait till death to sell the house. The trust could sell it as well. and we would go over the pros and cons of that. So we're going to be soon moving into the next section, but I'm going to turn it over to Constantina, who's going to talk about succession planning, a very important topic. Constantina?
Yes, thanks, Ron. So it's also very important, obviously, our overall theme here, again, we said is planning, right? Estate planning, long-term care planning, asset protection. It's engaging in all different types of planning. One thing that I think a lot of people don't consider is succession and business planning. And that is a very important topic because for many people who have started a business, maybe from point zero and built it and made something out of this business, you know, what happens to it when they eventually retire, if they eventually retire, right? So it's very important to put together a comprehensive plan to ensure that what that person built ends up the way he or she wanted it to end up, right? Where they wanted it to go. They got proper compensation for it. They planned ahead to ensure that maybe their family members are protected, maybe other investors are protected. And so the biggest and most important point of succession planning is that you have to make sure you have a good team together. Just like Ron said, with estate planning, you need a team. It's exactly the same thing with business and succession planning. You want to make sure that your team is established and that it works cohesively. I don't personally handle the business and succession planning. A couple of my partners do, but we were having a really good discussion actually before this. We met with clients who've built almost an empire, right? And they've started from zero and they're millions of dollars into these businesses. And while the businesses ran very well for many, many years, they're starting to have issues between the partners, right? Between the people who've been involved since the beginning. Or maybe a partner passes away and now their family jumps into gear to stand in their loved one's shoes to now take over. And there are rifts between partners. And, you know, it's very hard to sometimes have everybody continue to get along the way they got along for the last 40 years, you know? So the best thing that you can do for your loved ones, for your family, for your business is to ensure that you put together this plan. And I was talking to my partner, Joe Malazio, and he was saying, look, you really need to start this 3 to 5 years. I would recommend 5 years before your end date, before your exit date. And you need to put together this plan that will include your accountant that ensures that on your exit, you're not paying tons of taxes, right? Or that you're using the tax laws wisely to ensure your protection. You need your accountant, your attorney to ensure that you're protected from a legal standpoint, to make sure that once you're out, you're out. You don't have liability, you don't have any other potential exposure. You need your financial planner to ensure that, hey, if you sell it for X amount of dollars, or if you stop receiving a certain amount of income every month or every year, whether you'll be able to carry on your life the way that you have been, or to the manner that you want to continue to live your life. And so all of these individuals, and an appraiser as well, because you'll need someone to value your business. I feel like that's one of the biggest issues that I have when I'm talking to my clients about planning, is that sometimes people like appraisers and they cost a lot of money, right? So you may be shelling out thousands of dollars to get an appraisal of your business, but in your mind, you may have an idea of what it's worth, and it may not be worth that, right? So putting together this team will ensure that you get the maximum amount of money that you can for your business. It'll ensure that you have a seamless transition out while others may be coming in, whether you're selling or you're passing on to the next generation. You just want to make sure that you're not leaving behind the headache. A huge situation that I'm always faced with in our families is I'm Greek. I'm very Greek. My parents came here in 1984. I was born shortly thereafter, and they've built their own business, right? And so we were even faced with it in our family. My dad started a restaurant, and at some point he's like, I'm tired. I can't continue to do this. And so the discussions were had, and it was coming up with a plan of, well, how will we continue to keep this in our family? We've had the restaurant now for 32 years. It's an entire lifetime. The amount of blood, sweat, and tears that were put into that place are unreal between all of us. I've been working there since I was 12 years old. I still help on holidays. I still help whenever they need me because I grew up in the restaurant. I love the restaurant, but that transition was hard. It was hard for them to let go. It's hard for them to move on, and so we face these, and especially the family businesses where you may not have the documents in place to make sure that, every operating agreement I is dotted and T is crossed, to ensure that you've kept up with the minutes every shareholder meeting or member meeting. And all of that is very important. So finding the right attorney and the right advisor to help you put all of that together is important. And it really should not, it's really just something that people need to take into account as part of their planning, because without it, it could really turn into a huge mess for the people that you leave behind.
And I think a lot of that, Constantina, too, you talk about requires having difficult conversations and looking to moments when that you might not want to talk about things, right?
Absolutely. All of this is having hard conversations, talking about death. I mean, in my Greek culture, it's like a superstitious thing that you don't talk about dying because you might die, like it's just something we don't discuss. It's something we don't like to touch on. And I always joke with my clients, especially the ones that that have exactly the kind of thoughts that are those. And it's making sure that your loved ones know what you want. I have other clients who have said, well, I shouldn't have, they made a mistake. They gave part of a business to a family member who shouldn't have had it. Now they're stuck with the ramifications of doing that. And they don't want to have the discussion with that child to say, hey, do me a favor, give your interest to your other sibling because I've already given you something else. So these are hard conversations. These are hard circumstances, but it's important to put it all down on the table, talk about it, address it, and bring it to what it needs to be brought to and handle it the way it needs to be handled. Otherwise, you may walk away one day, you may pass away unexpectedly, and all of this remains behind in a huge mess. I always say it takes a lifetime to build an empire and 20 minutes to tear it down. I've seen so many families who have literally come here with nothing and have bought a house or two in Astoria. I'm a Queens girl. I'm from Astoria, born and raised. I always tell my husband, you're never getting me out of Astoria, right? And so, they bought a house for $40,000, $50,000 back in the 50s and 60s. Now they're worth 3 million, 4 million, and mom didn't do a will. And the house, mom promised me this house, mom promised me that house. And it turns into a fight. Just turns into attorney versus attorney, $400,000 later after years of litigation. What happens, right? This empire that was built is torn down. So you're right, Eric. It's a very crucial point of having these tough discussions, putting it all on the table and getting it done.
If I could interject, Eric, if you don't mind, and that was an amazing story, Constantina. I love that. Thank you. And Eric, you bring up a point, and Constantina as well. I find that the fear that people have of just making an appointment, they think about that difficult conversation, and then it translates into, maybe I just don't want to handle it this week or next week, and then they never handle it. They don't come into our offices and have that consultation that can help them tremendously. I find, I just want to get this off my chest, I find so many people who come in with trepidation and they're nervous and, and sometimes shaking when they're in my office. They leave with a big smile on their face that they did it. And many times clients say, this wasn't so bad. I said, no, it's great. You're, God willing, live a long time in good health, but you did your planning. And you should go out here and feel good about it, knowing that you're going to protect assets, protect your family's future and your future. And That's what it's all about. So I would say to everyone that's watching this, do not be afraid to pick up the phone and call us, call the elder law attorney and set up that appointment, because it's probably going to be the best thing that you could do. You're going to feel so much better afterwards.
It is. It's such a relief to put it in place.
Relief.
And then I hear it all the time. They're like, I was so intimidated. I was so scared. But this is easy. It's easier than I thought. You know,
Yeah.
and I understand there are so many more pressing things in life, right? And I always joke that estate planning goes on the back burner, right? You have to worry about feeding your kids on a day-to-day, going to work, waking up and functioning for other 10 million other things, but not realizing that there's this important thing of planning that if
Right.
you don't put it in place, you know, you're leaving behind you this potential mess.
Absolutely. It's such a relief when you do the planning. Pre-COVID, I clients would used to hug me all the time after the consult. Thank you so much. And I kind of miss that.
I totally miss it. I totally miss it. I say it on the way out sometimes. I'm like, I would normally hug you right now.
You're right, but not now. Not now.
Not now. For sure.
And I think there has to come, for people who have this trepidation and this fear, a sense of relief for having planning, not just on the financial side, but I think all of us, we look at friends, family, loved ones, and you hear stories, whether one that hits you immediately is personal or something you hear on the news, in the world of health, that not preparing for the health aspects and the long-term care, all of a sudden that can turn on a dime, maybe even more quickly than the financial aspect. You know, Constantina, and you're going to talk a little bit about, starting this segment on Medicare and the issues really of planning and preparing on the health aspect.
And those really are also linked from a financial standpoint and a health standpoint, right, Eric? So, you know, if you don't plan ahead to make sure you have the appropriate long-term care in place, you can potentially have a financial catastrophe, you know, and a huge misconception that a lot of my clients have is they think that, oh, well, I have Medicare. Medicare is going to cover my care. And it's sure, Medicare does cover care, but to a limited extent. Medicare is health insurance and is not long-term care. It provides you with health insurance. And so if you go to the hospital, if you have the required parts, A, B, there's C, there's D, there's so many different types of, so many different letters, and they change all the time, what they cover, what they don't cover, like everybody's health insurance, right? But parts A and B will cover 80% of your medical costs, right? If you have traditional Medicare. And that 80% will leave a 20% copay, which can be covered by supplemental insurance, such as AARP. So many of my clients have AARP, and they're so happy with AARP. It's one of the best insurances that you can have. And so while it's helpful to cover your medical costs, it's limited. Medicare covers just that, your health insurance. So in the event that someone fell and got hurt, let's say they broke their hip and they had to go to the hospital, Medicare would cover their 80%, leaving the 20% copay that would either get paid out of pocket or through their supplemental insurance. And then when they left the hospital, if they needed to go into a rehab center, Medicare would again pay for a portion of it. So this is where people have the misconception. They think, I'll just go to the facility and it'll be paid in full, but that's not the case at all. Medicare covers up to 100 calendar days, up to 100 days. The first 20 are paid in full. Again, this is traditional Medicare. From day 21 to day 100, there's a copay of about $180 or so a day. If you have a good supplemental plan, chances are they'll pick up most of it, if not all of it, for those remaining 80 days. But if you don't, you're paying out of pocket almost $200 a day to be at that rehab center. And like I said, Medicare pays up to 100 days. So you are not guaranteed a full 100 days. You may get, you may show that your rehab services are helping you, your PT is doing well, you're improving. And if you're improving, you'll continue to get Medicare. But if you start to show signs that you're plateauing, or you're not showing signs of improvement, or the rehab's not helping you, or you don't want to do rehab, Medicare will cut you off. So on day 22 or on day 46, they'll say you have 48 hours to leave the facility or to stay here for long-term care. And long-term care is not $180 a day. Rehab centers, nursing homes in let's talk about Nassau or in Long Island, right? Costing anywhere upwards of $450 to $700 a day to be in that nursing home for long-term care. And so it's very important from a financial standpoint that you do your planning ahead of time to ensure that come a time when you need that care, it'll be in place. And so there are a couple of different ways you can do long-term care planning, right? You can purchase a long-term care policy. If you've purchased one, I've seen a couple of like golden policies in my practice. I think it's only been 2 of them where the long-term care policy, basically you buy a policy that covers you for a certain amount of time. But I've had 2 very lucky clients who bought policies from before they became limited. So the person had long-term care for the rest of their life, which was amazing. But those are very rare. You would have had to buy a very long time ago, and the policy never changed because it wasn't allowed to change as per the rules of it. But typically what happens is if you buy long-term care, it's got a limited duration. So the insurance itself, you could be paying all these years, $3,000, $5,000, $7,000, $10,000 a year for this policy. And what happens is once you meet their criteria for requiring long-term care, such as not being able to handle 3 of your activities of daily living, whether it be bathing, toileting, transferring, feeding yourself, or any other activity that you would do on a day-to-day, in that type of a scenario, you would apply for your long-term care to start, wait a certain amount of time that they call a termination period. So maybe 30 days, maybe 60, maybe 90, pay privately for care during that duration. And then the long-term care will start to pay on a weekly, monthly, whatever basis the policy says. But essentially that policy will give you a certain amount of money on a daily basis to cover your home health aides, or to pay for you to be in an assisted living facility, or to pay for you to be in a long-term care nursing home facility. So those policies are great, but you have to pay for them. You have to be able to afford them. I actually recently, being in this type of law, right, being an elder law attorney, I have to plan ahead like we were talking about. So while I'm not yet in my 50s, I'll get there soon. But from my perspective, I already bought a long-term care policy. I coupled it with a life insurance policy. So we actually did it earlier this year. So we basically bought a policy where you pay annually for your life insurance / long-term care. If I get hit by a truck and I live, I can get the long-term care of the policy. If I get hit by a truck and die, my kids will get the life insurance policy. So we did kind of like a dual, and it was cost effective. It made sense, right? It wasn't just a long-term care policy, so that if I fell asleep one day, I wouldn't have wasted all the premium that I would have paid all those years. It pays out in a life insurance policy. So there are all these different types of plans that you can buy. There are a lot of different things that you can do to make sure that if you do need that care in the future, it's going to be there. So that would be if you paid for it privately. You buy the policy, you could buy it on its own, you can combine it with life insurance. There are other options that you can do. You'd speak to a financial advisor to figure out what makes the most sense. Or you can plan ahead to one day apply for Medicaid. And I'll pass over to Ron. He'll jump into the Medicaid aspect of things.
Okay, thank you so much, Constantina. I'm going to share my slides again. Let's see, here we go. Yeah, most of my clients are either not healthy enough to get long-term care insurance because they won't take you with any sign of dementia, Parkinson's, MS, severe osteoporosis. My mom couldn't get long-term care insurance. She had severe osteoporosis. So it's an issue. You can't get it. Many of my clients, most of them, can't afford long-term care insurance. So, they have to look for another way to pay. So how do you pay for long-term care? And that's this slide. Could either be private pay, but as Constantina said, that could cost up to $20,000 $1,000 a month. And that's unaffordable for most of my clients. Medicare is terrific, but it typically won't pay for long-term care. You could get the insurance. Most don't have it. Most can't afford it. And some aren't healthy enough to get it. Veterans benefits could be limited depending. The aid and attendance program was watered down a couple of years ago, and they have a 3-year look back with a potential 5-year wait if assets are transferred. So how do people typically pay for long-term care? They call us. They call and they want to speak to an elder law attorney, and they ask us all the time, how can you get us on Medicaid? How can Medicaid pay for my long-term care, either at home or in a nursing home? So I'm going to talk about Medicaid home care. There's going to be a 30-month look back. It was scheduled to start a few times. And actually January 1, it was just pushed back by the Department of Health to April 1, possibly even July 1 of 2022, but we'll talk about that. We'll talk about nursing home care. We'll talk about Medicaid transfers and some of the very basics. I actually teach Medicaid to other attorneys as well. And, you know, I spend hours just talking about certain parts of what I'm going to skip over. So you want to just know that these are the basics. That's why I have all of these slides available for anybody that wants to use these slides as a resource. So first question, how much in assets can you have and still be eligible for Medicaid? You could only have $15,900 in assets plus exempt assets. So I changed the law on retirement accounts and Medicaid. After the case that I didn't even have to argue, you know, we had a case with New York City in Queens years ago, and we argued that our clients' retirement accounts were exempt because we're SSI-related Medicaid, and SSI say that retirement accounts in payout status are exempt. And I never understood that. So I challenged New York City. The Nassau County came on board, and now it's statewide, had to be litigated upstate in Monroe County, but statewide retirement accounts. It doesn't matter if it's 100,000 or 500,000, retire or any amount. Retirement accounts in payout status are exempt. The well spouse can keep up to $130,000 and change, and that's exempt. If the applicant recipient is in a nursing home, they get to keep $50 a month, but the well spouse, if there is one in the community, keeps about $3,260 a month. For home care, individuals could keep income of $904 a month, and with a pool trust, as much as they need, you know, of their income to pay for their care. Now, this is just a very basic overview of Medicaid. And again, look at that third bullet point. Effective, according to the Department of Health within the last couple of days, this is guidance from them. The effective date of the 30-month look back for Medicaid home care has been pushed out back to April 1, possibly July 1 of 2022. And all of this is subject to federal approval from CMS. So what does that mean? All of this gibberish. It means that there's no look back right now for Medicaid home care. If we have a client that has, I'm just going to pick a typical client, has 300,000 in liquid assets, a co-op or a home valued at, let's say, 700,000, and has an IRA of, let's say, 300 also. That individual comes to us, and says, Ron, can you protect my assets? I need to go on Medicaid home care next month. I need it right away. It's bleeding me. I'm spending $15,000 a month on home care. Can you do it? Yes, we can get you financially eligible almost right away. We could transfer the home, co-op, or condominium into that Medicaid asset protection trust that I spoke about earlier. We could do the same thing with the other liquid assets. I'm simplifying this a little bit. The IRAs or retirement accounts would be in payout status, and if they're not, we'll put them in payout status. And that individual will be eligible for Medicaid home care virtually right away. It's more complicated than I'm saying. You do need to seek the guidance of the elder law attorney and have us do the Medicaid application. We have a very robust Medicaid application department, but what I look at this as, there's an unprecedented time and the window will shut, not by year's end. Sorry, this slide was a little old, but we just got the news. But by next April 1, that's the date that the Department of Health says there'll be a look back. So if anyone that's listening to this knows of someone else that needs help at home, or they're privately paying for care, now is the time to call us and we can get you on Medicaid home care without a wait. If it's Medicaid in a nursing home, there is a 5-year look back. Those rules have not changed. This slide talks about how that look back is calculated, but no matter what, even if it's nursing home care, people don't realize this, but we can protect half of your assets at the very last minute. As Constantina said earlier, there's no bad time to plan, but plan in advance if you can. But even if you don't, at a worst case basis, even if it's nursing home care and there is a look back, we could protect half of your assets. So call and make sure, call me, call Constantina, call the elder law attorney and plan ahead. There are exempt transfers that you could make. That's on these slides where Medicaid will say you made a gift, but that's okay that you made a gift. For example, to a spouse or a disabled child. There are exempt transfers of the home, their home equity limitations. There's pooled trust to preserve your income if you're on Medicaid home care. Before the rules change on April 1. And the next slides talk about that. I'm going to stop talking now, but use these slides as a resource so you see what's coming down the pike, you see what the law is, and plan accordingly and plan ahead. But no, if you haven't planned ahead, it's still not too late, because at a worst case basis, we could get you on Medicaid right away, pretty much right now. And even if it's nursing home care, at a worst case basis, we could protect half of your assets.
And if I can add to that, Ron, too, there's so many misconceptions by clients about Medicaid and whether they can get onto Medicaid. And, well, I have too many assets and my friend told me there's no way I can get onto it. I feel like Medicaid is the most talked about and the worst offender of the rumors, because most of my clients who come to me have no idea that I can help them qualify for Medicaid, that you can help them qualify for Medicaid. I was sitting with a client yesterday and the husband's been in a nursing home for 6 months. They had no idea we could do planning to move everything from her husband to her and to get him onto Medicaid in a heartbeat so she could stop paying $23,000 a month to the nursing home. And the biggest problem that I would say, again, goes back to planning. The problem is if you don't have the appropriate documents in place, like I mentioned before, the power of attorney is key for Medicaid planning, but it cannot be a printed off the internet power of attorney. The problem with the clients that I meet with is sometimes they don't have the right gifting powers in them. They don't have the statutory gift rider in them, or it's not prepared properly to allow for gifts to be made for Medicaid purposes if they do have it done. So it's very important that these documents not be done by a regular practitioner, PI attorney who hands out, powers of attorneys for breakfast and dinner. This should be a document that is prepared, exactly to Ron's point, by an elder law attorney who does this kind of work, who knows what to put into the documents.
Exactly. And we would typically, I'm sure Constantina does as well, typically add 30 plus extra provisions to that power of attorney that are needed.
Yeah.
So it's not just one or two. I know Constantina mentioned gifting. There's a slew of provisions that should be in that power of attorney to protect you, to make sure your assets are protected. And before I was talking about the window shutting for Medicaid home care, and you want to get in on the bandwagon beforehand, there's also a window of capacity that shuts. You can't just sign a power of attorney next year if you don't have capacity. You want to do it now while you know you have capacity, so it could be used after, God forbid. But if you don't have capacity later on, or you're in a hospital. And I know, Eric, you had mentioned, about the health planning and some situations during COVID. The saddest calls I got, and we got several, we don't have the documents. We don't have a power of attorney healthcare proxy. We didn't do the trust. We didn't do anything. My wife, and one of them was a very good friend of mine. My wife, I didn't listen to you. My wife is on a respirator. She has COVID. She's in the hospital. Now what? There are ways to do it, but don't let it get there ever. God forbid that should ever happen. Just, as Constantina said, as I said, and we keep hammering in, plan ahead. And if you haven't planned ahead, plan right now. That's how I look at it.
There's absolutely no time like the present, right, to get started. It's always by definition ahead if you start right now and you don't need it till the future.
It's so true, though. It's really so true. You're planning now for the future. Hopefully you don't need it. Hopefully we all just fall asleep when we're 96, perfect health, not needing Medicaid, not needing a home health aid, going about our day like we would right now. But it doesn't always happen that way for everybody. So you have to be prepared. And there really is no better time to start than the present, while it's still in your head, while it's still fresh, while you're thinking about it.
Do it now. Who said that? Nike, right? Just do
Just
it.
do it.
Just do it.
Just do it.
I would add, do it now. Just what you said, Constantina.
Yeah, for sure. And so there's also additional planning that one may want to do, right? Estate planning for gifting, estate tax. That's a hot topic right now. Estate tax is a huge point of contention. And the estate tax threshold changes every time the administration changes. Let's not, play around here. Every time we have a new president from a new party, there are new rules popping up for estate tax. For New York State, if somebody passes away and has more than $5.93 million in assets, their estate is taxable. For the federal government, if they have more than $11.7 million, their estate is taxable. But the threat at the moment is that they're going to knock that 11.7 down and come back probably close to New York. 5 million or so is what we're all assuming is going to happen. But it's scary because while 5 million sounds like a big number, if I talk to my typical client, like I mentioned to you before, my Astoria client who bought one house that's now worth a couple $1 million, or you speak to someone my age who has a couple $1 million in life insurance, that's all part of your estate for tax purposes. And so while people say, and you hear financial advisors say, oh, get life insurance, it's not taxable. Yes, There is no income tax generated out of a life insurance benefit. However, it's included in your estate for tax purposes. So one of the things that I do when I sit with my clients is before I meet with them, I ask them to complete a questionnaire. And a lot of times they're like, why are you asking such invasive personal questions? You know, you want to know how much is in each one of my accounts. Like, they're reserved. You know, they don't necessarily want to give all the information sometimes because they think maybe I'll charge them more because they have more money. I don't know what they're thinking, but that's not the case at all. You know, what's important for me to know is I need to know what you have so I can give you the appropriate advice. I always joke about one client that I had met with. He's an older Greek man, actually, and he walked in and I asked him about assets and things like that. He didn't write anything down on the questionnaire. He was holding back on me. And so I said, give me a little bit of background about your financial picture. And he's like, I have like $75,000 in the bank. I have the house we live in, and that's really it. So then I gave my spiel. I talked about the state taxes. I talked about Medicaid planning. I talked about the importance of the appropriate documents, kind of like everything that we just talked about now. And so when I'm done discussing, he's like, okay, so I have $750,000 in this account. I have 4 houses. One is in here, one's there, one's in the other place. And he kind of let it all out, right? But if he didn't have that moment of, okay, let me tell her what my assets are, and he just held back on me, he would have gotten a much different estate plan than what I would give him once I knew the truth, right? And so that's very important. It's very important to be clear with your attorney. This is why LegalZoom doesn't work. This is why going on the website and printing out a document, it doesn't work. There's no cookie cutter estate plan. Every estate plan gets tailored to that individual. If estate taxes are a concern, they should be addressed in your estate planning documents, right? And there are certain ways, certain trusts that we set up within wills. There are certain other provisions that we put into it. You have disabled beneficiaries that Ron's going to touch on. You set up certain trusts within your will. You have minors like I do, 2 little kids. In my will, it says when my kids inherit their assets, they're not going to be lower than 35 years old because mommy likes to control from the grave. She sees way too many problems of young people getting money and blowing it on really nice cars, right? So it's very important that you're open with your attorney. You explain to them all the facts, family members you don't like, information about people who may be spendthrifts. You may have a child who's loose with their money, that you're concerned that they may lose it. Telling your attorney that your child may have creditor issues, may owe, credit card debt, may have a spouse who's money hungry that you want to protect them from, may have other types of creditors. There are so many different things that can be put into your estate plan to protect your beneficiaries. But unless you tell us about them in the meeting or in our meetings, there's no way for me to plan that. So it's very important that you have that open dialogue and that trust with your attorney to explain all of this to them.
Eric, how would you want to handle this? Because I know where time is up, and I have so much more to talk about, but I don't know how you want to handle this.
I think, yes, we're getting a lot of questions coming in also, and so many things to talk about. Maybe if you want to take a minute or two to talk about the special needs trusts. And then when we're done with that, we'll go on and we'll answer a few of the questions. And then everybody, as Ron has said, all the slides, his presentation, they will be available to you. We'll send them out to everybody who has signed up for this webinar so you can soak this all in, and you don't have to pay every little bit of studious, I'm a student in class attention, write out all the notes. We'll make sure you get all the information from them. But yes, please, Ron.
Okay, great. So I'll share my slides again just for a little bit. All right, so here, I'll just talk about, there are so many different types of trust. Constantina mentioned trust for grandchildren or children, your minors. Spendthrift trust, as Constantina said, there might be a child that's not good with money. So you want to make sure you protect the money for that individual. But if there's a special needs or disabled child or individual that you want to provide for, we can actually create a special needs trust, which could be a part of your will, or it could be a standalone trust for that disabled child with special needs, or anyone else with special needs. There's a third-party special needs trust, and there's a self-settled trust. But there's no Medicaid. Medicaid can't touch any of the assets in that third-party supplemental needs trust. So if it's a parent trying to provide for a child or a third party with the parent's money, that's no issue whatsoever. And again, I know there really is no time. So these slides will go into the special needs trust, spendthrift trusts, the life insurance that could take, as Constantina said, life insurance part of your taxable estate. It's the life insurance trust. Get that out of your estate. And if you do have assets and you don't have a trust that your assets are all in, we will do the probate. And probate is not a 4-letter word. You could count the letters there. It's not so terrible. We'll do it for you, whether it's in New York City or Long Island or Westchester, wherever it might be. Probate in New York isn't as bad as other states, such as Florida. These next slides go into the procedure of when you would need probate and how it works and liability, et cetera, and the estate taxes and the importance. And I just want to mention one thing, because nobody has touched upon this yet. When a spouse dies and you don't use up that exclusion, currently New York State is 5.9 and change million, federal is 11.7. I would predict likely going to be halved under these new proposals, but you want to think about filing an estate tax return at Form 706 so that any of the unused portion, let's say it goes down to 5 million, just make it easy, and the spouse had 2 million that's used, there's $3 million left of a freebie that can go over to the surviving spouse if we file the 706, that estate tax return, within 9 months of death. So it's the attorney that's going to think about all of this and more. And right now that's 11.7 million. Maybe that won't change. We really don't know. But this could mean saving millions and millions of dollars. So I would just say there is postmortem after death estate tax planning that we do all the time. And this is us, but these slides are going to be available to you. Let me stop sharing. Let's take some questions. Eric, take it away.
All right. And never stop sharing. That's what it's all about. It's sharing your knowledge, your information. So we do have a number of questions here. I'll start out with the first one. Do my wife and I need separate wills and separate powers of attorney, or can we do one for both of us?
I'll make it very short. Yes.
Yes.
Constantine, you want to elaborate, or I think it's a yes too, right?
It's absolutely. It's absolutely.
You need your own.
There was one long time ago, before my time, that women, were bound to their husbands financially, right? And then maybe they did one will, but absolutely, everybody needs their own separate documents, and it's very important that those documents, while not needing to be updated all the time, I always tell people to look at them every 5 years. Your circumstances may change. Your life may change. Things may be different, right? And it's good to take a look at the documents and give fresh look to them, make sure that they still reflect your wishes. But the answer is absolutely, you have your own individual documents that get used for you personally.
Very, very good point. Your life may change. And what if the tax law changes? I mean, we have these proposals, the Ways and Means Committee, just Google it, you'll see all of these proposals. If that changes, you might need a different type of trust. You might need a different type of will. Planning needs to be done. So, we'll see what happens. But yes, each spouse needs their own documents.
And that question of changes actually leads into our next question. How often can I make changes to my will or my power of attorney? And is it ever too late to make a change?
Ron, should I take this one?
I'm happy to. You can, whatever you want.
Sure, go ahead.
Okay. It's never too late, but what did Constantina talk about initially? If you lack capacity to change your documents, then you can't change them. So you have to understand the nature and consequences of the document, the will, the trust, the power of attorney, etc. So yes, you could make as many changes as you want, unless maybe it's an irrevocable trust. Even then, maybe you could change that. And we do that all the time. But one day, I think Constantina, you mentioned it. Whoops, sorry about that. One day, we're all going to pass away. It would be great. Like in the news today, there is 107-year-old twins from Japan that are still pretty active. That's amazing. But that's not going to be 99.9% of us. And we are going to need the planning. And if you lack capacity, you lack the ability to do the change. So the documents have to be done with lots of foresight to anticipate things that might happen.
Exactly.
And then I'll have one more question here, and I'll give it to both of you. You can each give the answer. My wife and I are 58 years old, and we have not done a thing yet for our planning. What is the one best place where we should start?
I would
See you,
say,
Bernie.
call us. Whether it's myself, whether it's Constantina, call us, do the planning. And I think we spent a lot of time on, don't be afraid to plan. People that see us, we do have separate firms, but we really respect each other's other firms. And see us. You're not going to be unhappy no matter who you call. Call the elder law attorney, call the estate planning attorney, i.e. call us and plan and just do it. Just like Nike says, just do it.
It starts with a call. And I think that's the hardest step, that people say, oh, I'll do it. I met with a client yesterday whose uncle promised him property in Pennsylvania, promised him all these things, and just kept saying, yes, we'll get to it, then had a stroke, and now it's too late, right? And so I think that first step is exactly what Ron is saying, and find the person that you can work with, whether it's speaking to one office, speaking to another office, see who you would like to speak to, and go forward. But it should be a trust estates elder law attorney. Because this is what we do, and this is what we're geared toward. It's making sure that you have your planning in place for now and the future.
So many first steps to take. Bernard, you started us out tonight on our first step. Would you like to take our last step and bring us home this evening?
Absolutely. I want to thank everyone for being here tonight. Thank you so much, Ron and Constantina. Wonderful presentation. I loved hearing the personal stories, right? The stories of your clients. Constantina, I grew up in Jackson Heights, and I have plenty of friends in Astoria who still live in Astoria. That those stories come back to where I started. There's a quote, right? Plans are nothing, planning is everything. So these are tough conversations, but they have to be had, right? I mean, you have to have these conversations. I do want to share that with AARP, when you're talking about planning for yourself, planning as a caregiver with your parents, and sitting down and having that conversation, one way to start, and before you seek legal counsel, is AARP has what we call our Prepared to Care resource guide. It's free. You can find it online at aarp.org/caregiving /prepare to care planning guide. If you can't find it that way, you might want to just Google it. But it's what we call our Prepared to Care resource guide, and in it, we share a lot of great information on how to have these vital conversations and assess not your loved one's needs, but also what their financial needs are. We help you organize important documents. checklists, contact lists, for legal counsel, for attorney like Ron and Constantina. This makes your life a little easier because we have all that information already kind of filled out. So folks can fill that out. You can download a version of those that guide, or you can ask for an actual printed copy. You can call AARP for a printed copy, and we'll gladly mail it to you. But again, it's a Prepared to Care, a planning guide for families, and I encourage you to get yourself a free copy of that and just start, filling that out. And again, like I said earlier, plans are nothing. Planning is everything. So just a reminder for next month, we have our webinar, and we're going to be doing, again, a special personal fulfillment program on how to best declutter your space and declutter your mind. And it's going to be, a real good cleansing moment for a lot of you folks on your home and your personal. So we're going to have experts on that. That's on Thursday, October 14th at 6 p.m. And you can register. Maybe a lot of you have already registered at liherald.com/self. And folks, if you're looking for another topic for next year, I think we'd like to, continue looking at this, health, wealth, and self. If you'd like to hear or learn more about, other topics, just drop us an email at nyaarp.org at AARP. I'm sorry, nyaarp@aarp.org. You can always connect with us at AARP Long Island by visiting us at aarp.org/near-you. Again, to learn more about other webinars and classes, at-home activities, upcoming events, and volunteer opportunities. Or you can find us on Facebook. Like and follow us there at facebook.com/AARP Long Island. And again, thank you for this evening. Thank you for all, the wonderful presentations today. Again, thanks, Ron and Constantina.
Thank you.
Thanks for
everyone.
having us.
Yeah, thank you. Take care. Thank you, Eric. Thank you, Bernard.
Thank you so much. Again, a great, informative, fun, engaging night. Bernard, thank you to you. Thank you to AARP. To all our guests, thank you so much for joining us, watching us, tuning in. As Bernard said, planning is important. So again, plan to be with us again on October 14th. I've already started cleaning off my desk, reorganizing everything. It's going to be another transformative night. You can find out more information about that webinar and others at liherald.com, right there on our homepage. Again, thank you so much, and we'll see you again very soon. Good night.
Thank
Good
you,
night.
everyone. Good night.